So let's get started with the usual adopting the agenda. No problem about that, I guess, with the usual announcements as to the linguistic conditions of our work, which I am escaping, and then no endorsements of appointment by the coordinators this time, and the usual chapter of delegated acts and implementing acts, which I am also escaping for the sake of time saving, so that we move right to the first point in the order of today, which is legal migration, skills, hi, how are you doing? And talent package. You know that migration is one of the most relevant policy and lawmaking fields of action, and we have a point on legal migration. We're always insisting on legal and safe pathways to the European Union so that we crack down on the business model of illicit trafficking of human beings. Smugglers, irregular migration needs progressive replacement for legal migration. Talent package. Now, there are mandates on the latest Commission proposals, published last April. Levy, our committee, is making a point on keeping legal migration in the center of our attention. We have been working hard on the common European asylum system with a new balance. Now, we are approaching the trilogues with the Council, and we have an expectation of having the work done and deliver on the matter. But then we are also discussing, from the point of view of demography and economy too, how to enhance legal pathways, legal migration tools, which are to be discussed today. That is the only way to keep up with some other regions, as the case of America or Australia, which have strong legal migration tools. And that is why we have put in place single permit, long-term residence directive, among other instruments we had adopted in the first mandate in which I chaired the committee, including seasonal workers, posted workers. And we're having today some ground for discussion on the reports which are ongoing as to the recast procedures that I have just mentioned. We have a couple of panels from now onwards. The first panel is inviting Professor Steve Pearce, which is accompanying here in the side of the podium, Essex University. He will be speaking for 8 minutes, and then it'll be Teresa Hornung, German Business Association and Business Europe, which will be taking the floor also for 7 minutes. And I suggest, after having heard from this first panel, we open the floor with the representatives of the political group. There will be a first round of 2 minutes questionings, and then some 2 minutes to respond from the side of our panelists. If I'm not mistaken, there will be a third panelist in the first round. Yes, in the first round there is a third panelist, Michel Levoy from PICUM, NGO Cooperation Platform for Undocumented Migrants, also for 7 minutes. But let's go one by one now. It'll be first Professor Pearce. The floor is yours, 7 minutes.
Okay, thank you very much. It's always a pleasure to be invited here to talk about immigration issues. And I'm going to focus on what the Commission's paper calls the forward-looking pillar, the 3 ideas for future legislation. Before I mention them, it's also important to mention the plans coming earlier for a proposal on a talent pool. I think it will be important to scrutinize that from a data protection point of view and an efficiency point of view, to see that it's a useful contribution to obtaining labour from non-EU citizens. And secondly, there would be a proposal on recognition of qualifications, which will again be quite useful. It will particularly ensure that third country nationals with qualifications outside the EU, recognised in the EU, have capacity to work in member states, perhaps at the level of their training and expertise. So, a doctor won't be a taxi driver if they have the capacity to work as a doctor. So, on the three proposals, does this work? Yes. So, in the communication, the Commission mentions long-term care workers, youth mobility, and an innovation visa, and possibly other proposals on other low or medium paid workers. But I'll focus on long-term care workers because perhaps that's easier to fit into the existing legal framework of paid labour migration. Now, the study for the European Parliament suggested adding long-term care workers to the blue card law that's already in place. There are different ways to do this. You could add it to the single permit directive, or it could be a separate law. But either way, the same issues will arise. So I'll look at this, the blue card, by way of example. So, is it, first of all, the same scope of people? Do you let refugees who are now covered by the blue card law apply or not? Do you exclude the same people who are excluded by the blue card law? Do you include the same people who are included by it? Or do you have some different question as to who is covered? I think it's particularly important to ask if beneficiaries of temporary protection would be included, especially if the current temporary protection for the Ukraine invasion is extended, because then we'll have a lot of people on the territory who might want to transfer their status when temporary protection ends. So, as with the single permit directive and others, that's an important question whether you exclude that category of people now. Jumped. Let's see. Another question is whether you need special admission criteria above and beyond what we already have for the blue card directive. Another question is whether to keep a labour market quota possibility for member states. That has to remain because the treaty requires it. But do you keep a labour market preference test? Do you keep an ethical recruitment exception, which is in the blue card law? I would suggest yes, but you could discuss that. And then what happens in the event of unemployment, or if you want to change jobs? So that was a difficult negotiation under the blue card directive. I think it's about to be a difficult negotiation for the single permit directive, where the Council and Parliament have different views on those issues. So I imagine there could be a debate about that. And if you go with the blue card rules of 3 months or 6 months worth of unemployment, that's more generous than what the Council thinks should be the case for single permit holders. So it will be important, of course, which approach is chosen. Another question is whether to have a standard period of validity. Is the idea that care workers would only be coming for a short period of a year or two, possibly renewable, perhaps even sent home after that? Or do you give flexibility to member states to decide that? So are we treating them like seasonal workers, or treating them like someone who has the possibility of long-term residence, as blue card holders or researchers would do? Of course, if you're wanting to attract people to the European Union, it makes more sense to have a longer period of validity. There'll also be a question, do you accept in-country applications for people who are here legally on another basis? Do you have rules limiting fees, not just by administrations, but on what employers charge workers, which can be very high fees for recruitment in this field? Do you have a fast track for selected employers? Do you have a deadline to consider applications? If so, what is it? That's something which the Parliament and the Council have often argued about before. I've already mentioned what happens if there's a change of employer. Another question will be equal treatment, whether you have the same rules on employment. And here I have to correct the study that was done for the European Parliament that says the Working Time Directive does not apply to third country nationals. In fact, there's nothing in the Working Time Directive to exclude third country nationals. If you look at the footnotes, the study confuses two different directives. And the Court of Justice, in the case I list there, Tuma, has said that another EU employment law applies not only to third country nationals, but even to third country nationals who are not legally resident. They get employment law protection under EU law. Doesn't change their immigration status, but they do have employment law protection. And then finally, I won't have time to comment on the other two proposals. The questions will arise, do you have a derogation from the Family Reunion Directive, which has been negotiated for the blue card, some other measures? If so, what exactly? Because long-term care workers might want, obviously, to bring their family with them. Do you make things easier, not having to have a prospect of permanent residence and so on? And do you have derogations also from the long-term residence directive, as some other EU legislation does, to make it perhaps easier to be a long-term resident, at least to confirm that long-term care workers can be an EU long-term resident, because that may be an important factor in whether they wish to come to work in the European Union. So thanks very much, and I look forward to the discussion.
Thank you for your presentation, Professor Peers. Now let's hear from Teresa Hornung. The floor is yours. 7 minutes.
Thank you so much, dear Chair, dear members of Parliament, dear Libe Committee. Many thanks for inviting me to today's hearing on the way forward in legal migration. And I'm glad to have the chance to bring in some of the ideas and thought of the employers. I'm from the German employers, however, I will also represent Business Europe and the entire EU business community today. The EU business community supports a holistic skilled labor strategy, in which labor migration, of course, forms one crucial pillar. So the key question is, how can we better attract and retain talent from abroad? Anyone who wants to come to work in Europe today is faced with a bureaucratic jungle. We need to make the administrative procedures as well as the legal framework more attractive, more customer-oriented. We need simpler, faster, but also more digital administrative procedures. And especially the long waiting times for the visa appointments need to come to an end. And of course, that's all national responsibility, right? We're talking about national authorities. However, the EU can, and already does, set binding requirements here when it comes to guaranteed processing time. So one part, of course, to tackle current shortcomings and gaps is stronger enforcement of directives, and we have pretty much 7 directives that govern the admission to and residence in the EU for third country nationals. Another important part is information campaigns to actually make third country nationals aware of all the procedures in place, because most of the time they just don't know. And of course, we also need legislative measures to tackle inconsistencies, and that's what I focus on today. A lot of good work has been done already by both the European Commission and the Parliament. I really want to say that in all clarity. We have a very well revised Blue Card Directive, so now we just need to aim for an ambitious national transposition of that directive. We have the recast of the single permit directive. Congrats, Mr. Sanchez, and congrats to Damien for the long-term residence directive. I do hope for good and ambitious trilogue results here, so fingers crossed. But the question is, of course, what's up next? And here I would like to make 4 points. First, the European talent pool. And as we currently discuss with the European Commission the different policy options, and it's quite likely that it will be a legislative option, I took the liberty to include it into this part of the panel. So an EU-wide talent pool that allows employers, but also very importantly public employment services to post vacancies and allow third country job seekers to view them and then to actually facilitate a matching, that has, in our opinion, a lot of potential. Of course, this can only be successful if the talent pool is of added value, and that's what we're all working on quite intensely right now. It should be simple for all involved actors. We need to avoid parallel structures, and possibly most importantly, it needs to allow for technical interoperationality with national systems and tools. There are a lot of questions, like right now it's really the nitty-gritty part that counts and will be decisive for the success of the talent pool. We could, of course, start with a gradual, it could be a gradual approach in which we start with a focus on sectors of indeed strategic relevance to our European labor market, so talking about shortage sectors. But I think in the long term it will be less bureaucratic and also will cost less resources to actually have a broad approach of a talent pool open to all kind of sectors. So those are the thoughts very broadly on the talent pool. The other one is, how can we better harness the potential of foreign founders? We do face, and I mostly talk about Germany right now, but I'm sure it's an issue in other member states as well. We have issues attracting non-European startups. When it comes to the procedures, it's often that authorities require documents that are actually not provided for by law. They want outdated documentation and so on. So often there are still legal hurdles, but mostly hurdles in practice. And if we want Europe, and we talk about innovation all the time, if we want Europe with an entrepreneurial spirit, then that entrepreneurial spirit also needs to be reflected in our legislation and in our administrations and in our society. And so far it isn't. So we as a business community would like to advocate for a special European startup visa for founders. It would be a strong signal to all talented people worldwide that their ideas here in Europe are welcome. And the question is, of course, how could that look like? It should be simple and quick to implement. It should create attractive framework conditions. And member states could be asked to establish central national bodies, for example, that evaluate and coordinate the business plans, that advise on funding opportunities. But most importantly, which isn't the case right now, that the submission of business plans is also possible in English, but also that the actual application procedure, the information, the guidance, that all that is also available in English. I think there we face a lot of shortcomings in most member states. My third point is the EU Family Reunification Directive. So we had a lot of, quite a few recasts and revisions so far, and we do believe that this one needs one too, because it is quite outdated. It doesn't directly promote increased labor market participation of family members. So I think here we really need to simplify the requirements for and examination of an application for family reunification. We need much faster notification periods for the competent authorities. I mean, right now it's 9 months. That's the blue card is there. There we have immediate labor market access of family members. The ICT directives, it's up to 90 days. And here we talk about 9 months. That's ridiculous. So in general, we need also less bureaucratic procedures. And here I'm talking also about labor market tests, because it can take up to 1 year for family members until they have labor market access, which in times of labor shortages is maybe not the smartest thing. And I'm getting to my last point, and that is indeed the recognition of foreign qualifications. And there we have an upcoming proposal by the Commission this autumn. And here I just want to emphasize the formal recognition of qualifications in non-regulated occupations should not be mandatory. We shouldn't make it here so complicated. In most cases, we can carry out also qualification measures in the company on the ground, which is often so much easier than doing it all pre-arrival. And when it comes to regulated professions, and I know that's a more sensitive topic, we need to accelerate and simplify procedures. And here also some unbureaucratic skills assessment might be interesting to talk about. And so I'm looking forward to the upcoming legislation here. And I think the guidelines on the recognition of Ukrainian qualifications issued by the Commission last year is also maybe an inspiring example to look at how we can actually, if there's political will, make things easier and less bureaucratic. So let me close by saying a welcome culture really begins in our administrations. It begins in the visa offices of our foreign missions, as well as after migration, and of course it extends to our entire social life. And I think that welcome culture is something that needs to be the guiding principle for the way we make laws. And I think there we still have some space. Thank you.
We thank you, Mrs. Hornung. Now let's hear from Michelle Levoy, which is our third panelist, 7 minutes, and then we will start the discussion one by one, political groups. Okay, there you go.
Thank you, Chair. First of all, as PICUM, we definitely welcome the European Parliament's commitment to regular migration. But there I want to say we welcome to regular migration. We actually, as PICUM, use the UN terminology, which talks about regular, safe, and orderly migration. It doesn't talk about legal migration. And the reason being is because if I say legal, you will probably automatically think of the opposite, illegal. And this is what we're trying to avoid, is these terms that actually create stigma and criminalization. So going forward, I actually wanted to start off with narratives, because I think what we continuously hear, the Chair mentioned it in the opening, why is the EU embarking on this path to also make the EU competitive? We saw the World Bank issue last week, the World Development Report from 2023, where the narrative is once again about regular migration. But we as PICUM are a little bit concerned that some of the narratives at the EU level, actually around attracting talents and the focus on workers' skills levels, don't really fully reflect the realities of labor migration. Because there are workers in many crucial sectors for economies that are considered low-skilled, like care, we've heard, agri-food, hospitality, construction, workers who are not well protected, and yet a lot of sectors rely on the presence of these workers. But there's not a lot of possibilities to do this regularly. And many migrant workers are pushed to work irregularly and take undeclared jobs. So in my input now, I just want to highlight some key points on the single permit and the long-term residence directive, and then briefly at the end on the talent pools. But key points where we think in terms of the Parliament's position in the negotiations going forward, it's crucial to retain some of the things that have already been adopted. So the first one on the single permit, the scope, Article 3, we fully embrace the position of the Parliament to include categories which have so far been excluded from the single permit. So to include seasonal workers, to include au pairs, beneficiaries of national forms of protection, and beneficiaries of temporary protection. On the right to change employer on Article 11, This right is key for workers to be able to more easily stand up for their rights, to challenge exploitation and leave abuse of employment. The way that it's been adopted now in the Parliament with this subject to the mandatory notification procedure is fine, obviously, but we can't have this be cumbersome or burdensome on workers. So it's crucial going forward when it's negotiated that it's not considered kind of a new formal application. We're a little concerned with the Council's position, which would allow member states to require an application from the worker to change employer and to set a minimum time period before a change of employer is permissible. This would actually make the right to change employer unworkable in practice and could lead to too much flexibility from member states and uneven rules across the EU. On the period of unemployment, Article 11, this is crucial because we don't want to see situations where job loss would lead to the loss of the permit, and that would make people become undocumented. So we're very much in support of the Parliament proposal to introduce a period of job search of 9 months, which is in line with Directive 2016. On the right to information and procedural guarantees, Articles 9 and 11, this is key to upholding workers' rights. So this is concerning not only the length of the procedures, but also the possibility for permit applicants or workers to change employer to start working while they wait for the authorities to process their application. Here I wanted to highlight a case that we've collected as part of research that we're doing on the single permit application as it is now in 3 countries, in Belgium, the Czech Republic, and Spain, that we're doing with the ULB Equality Law Clinic. And this concerns a case of an individual who completed a master's degree in Belgium and who later obtained a 1-year job-seeking permit. During this period, he found a job, he was offered a permanent contract. But when his job seeker permit expired, his employer applied for a single permit on his behalf. He received the first rejection after 4 months, which is the maximum time national authorities have to give a response. But when he lodged an appeal, he had to wait more than 7 months without a response before his appeal was dismissed. And during that time period, he couldn't work. So he endured a total of nearly a year of waiting without work, which obviously caused significant hardships. The other issue is monitoring and facilitation of complaints, Articles 13 and 14. Very much welcome the Parliament proposal to extend the single permit for 12 months for migrant workers who are victims of serious violations of their rights to find an alternative job with full access to the labor market. And we also think it would be good that member states make better use of existing permits, for example, under the Anti-Trafficking and Employers Sanctions Directive frameworks. And the second point on the long-term residence directive, we very much welcome the EU's EP support to the proposal to lower the stay in the EU for 3 years instead of 5, with 1 year of stay in the member state when the person applies. And these would also be important points to keep in the negotiation stage and the trialogues. So the possibility to have interruptions between residence permits. So for example, if someone becomes undocumented and doesn't have continuous stay, and interruptions between work contracts, important to keep. Evaluation of, quote, regular resources should take into account all types of social assistance and protection measures the person's entitled to by national law. But the inclusion of certain types of assistance by the Parliament is an important step in the right direction and should also be kept in. Children of EU long-term residence permits should be granted a permit irrespective of place of birth and without other requirements. And the autonomous permit for family members, so not only spouses, should become automatic after 2 years and possibly after 1 year, as in the Parliament position. And finally, briefly on the talent partnerships and the talent pool. On the talent partnerships in general, we feel that if public EU funds and resources will support labor migration schemes in particular, they should, at the minimum, include additional safeguards to ensure migrants' rights and good administration overall. And on the talent pool, we do have some doubts as to the effectiveness of it, because improving recruitment will not solve the question of the admission of workers and the lack of decent labor migration pathways. Member states now actually have a patchwork of labor migration policies, and having the new single permit would be a more horizontal solution for workers to come to Europe. So we actually see the value added of the talent pool, would be to promote fair recruitment standards. A lot of this work is already done by the International Labour Organization, but that's linked to the quality of permits. So just to conclude, where we recommend some principles for the talent pool would be transparency and participation of all stakeholders. This means trade unions, civil society organizations with migrants should be involved at all stages alongside the private sector. We should also take into consideration different income levels, skills, and labor sectors, and look particularly at sectors which currently have high levels of exploitation. And finally, the lack of information is one of the key gaps in labor migration pathways. So we need to make sure that people are fully understood of their rights, not only at the recruitment stage, but then afterwards as well. Thank you.
Thank you, Mr. Leboy. Thanks our three panelists in this first round for discussion. Now I suggest, considering that there are three, and you are going to be given the floor one by one, political group, for 2 minutes, I suggest they take note of the questions that you are about to raise so that they have a common round to respond. Okay, it'll be 2 minutes every political group. First floor to Jerome Lenners.
Well, thank you, Chair, and thank you to all three of the panelists. It's been a pleasure listening to you. It's a little bit odd in the timing because, of course, lots of the work on both of the pieces of legislation has been done already, but it's good to hear your support for the positions of the Parliament and the inspiration surely that our two rapporteurs have gotten also for the upcoming trilogues. A couple of short questions. Mr. Pierce, first of all, I'm a big fan of your blog, so it's good to meet you here in person. And I remember, and I know it's a long time ago, so forgive me if I paraphrase it completely wrongly, but I remember around the times of Brexit, you once wrote a blog where you said that even though there is a sound economic argument for freedom of movement within the European Union, and there's full support for it, there's also a political and a societal context, which meant that even pro-Europeans should consider being a bit tougher on free movement in order to maintain it for the future. I was listening to the debate today as well, and everybody is very positive about the added value of regular migration, to stick to the narrative. Do you see the same risks there? Because I think, indeed, there are sound economic arguments for making legal migration easier, for having more legal migration in the European Union. But at the same time, we see that it is a hugely divisive policy, political discussion in many of our member states, particularly in the context of increasing numbers of irregular arrivals in the European Union, reaching the numbers of the crisis years already. How do you see this tension between the sound economic arguments, but also the many concerns that there are in our societies when it comes to migration as such? Secondly, on the recognition of qualifications, I come from a cross-border region in the Netherlands, and we see that even recognition of qualifications within the European Union, even between sometimes very similar member states, can be hugely problematic, with very, very bureaucratic problems for the persons involved. How do you envision this, and this goes to all three of you, for having this recognition of qualifications with third country nationals, if even within the European Union we still sometimes fail to do it in an effective way? You mentioned more digital procedures, less bureaucracy, etc. Maybe if you could elaborate a little bit on that. And how do we make sure, you were somewhat skeptical about the talent pools, but I think maybe one of the good ideas of the talent pools is that it also increases access for smaller companies. How do we ensure that when we talk about labour migration from third countries, it's not only something that big companies in the European Union can benefit from, but also that those SMEs that are in need of a skilled workforce can benefit in the same way? Thank you.
Okay, thank you, Jerome. Now it will be for the S&D, Javier Moreno.
Gracias, Presidente.
Thank you very much indeed, Chairman, and good afternoon, everyone. First of all, can I thank our guests? I'll just give them a chance to put their headsets on. I wish to thank them for their presentations. We, as legislators, have to do our work here, and we very much rely on contributions from the academic world, but also from civil society. And Ms. Levoy, I think you're quite right on that point you made about the narrative. We have to change the narrative, and whether or not we talk about regular, irregular, what have you, we need to change the perception around the issue of migration. We know that there are certain political forces that seem to be breeding fear and worries in order to score points and get votes, when the reality is far from that, and the reality is more positive. And I think the real instrument to manage irregular migration is to have an instrument, and whatever we wish to call that is another point. What we have right now is a patchwork of legislation, 7 directives, and it's difficult to make sure that everything's coherent. I was a rapporteur on the Blue Card directive, now I'm the rapporteur on the single permit, and it's true the European Parliament has ambitious proposals, and we've been working very well across the political groups, and now the next stage is to try and reach an agreement with Council. I don't know whether the Council have organised these kinds of hearings with you, but I think it's very important that we get Council on board, and that we can get them on board with the Commission proposal and have a good outcome. Because there's one concern that we have on equal treatment and respect of migrants' rights, but the real needs of our businesses, and is another point that you very rightly made, the real needs in the business community, that they are going to rely on these migrants. And of course, the member states will want to keep some degree of control, but SMEs, all-sized businesses, really need this workforce. And a final point, I think it's very important that we work together on information and provision. There's no point in having the best possible directive if no one's aware of it. And that has to be something that we make sure happens in origin countries, transit countries, and destination countries. We need to really ask Council to organise information events, information campaigns, and through NGOs, civil society as well. We know that their work is crucial in this field. And I think I'll stop here because I could speak for hours on these topics. Thank you, Mr. Moreno.
Now we from the Renew Group, it'll be, I see, Mrs. Al-Salani. Mrs. Al-Salani, there you go.
Thank you, Mr. Chair, and thank you, our dear guests, for being here. It was very interesting listening to you and also confirming many of the information and knowledge that we already have, but also enriched our perspectives with new knowledge and perspectives. I worked on the Parliament INL report on legal labor migration, as well as long-term residence directive, along with Mr. Boslager here, and also on the single permit directive. So I have approached the labor migration from many perspectives and on different legislations. I have a trouble making some of the political groups here understand that the EU is not the most attractive region for skilled competence to come to. We still believe we have this self-imagery of being the most attractive place to come to, when in reality we are competing with both the US, Canada, and Oceania about the skilled labor migration, but also the lower skilled labor migration. And this is actually causing us big troubles, because in Sweden, almost all branches, all businesses or types of businesses, sectors, are saying that they are not being able to actually recruit from home. There are not enough people with the certain needed set of skills that they can have, so their businesses can thrive, and also in that way contribute to our welfare. So I have actually two questions. The first one is the integration issue. We are asking for to have integration musts in the second member state, because we do believe that making EU more attractive is also about making EU intramobility possible. And with that means that your rights have to be portable. So if you already have demands on integration in the first member state, and then you find a job in the second member state as a labor migrant, do you believe that the demands on integration in the second member state will actually hinder the intra-EU mobility for labor migrants? And my second question is about the talent pools. Well, the representative from PICUM was a little bit skeptical, but in my mind, the talent pool was a way to make the EU labor market accessible, even for a refugee in Kenya who has, fled, for example, the war in Sudan, and have a smartphone, so they can access the talent pool. But the issue is, how can we make it easier for the validation of the skills? Not only the diplomas, because diplomas is one thing, skills is another thing. Do you have any ideas about how can we make it doable and more also user-friendly, both for the labor migrant, but also for the employer when it comes to the validation of the skills? Thank you so much.
Okay, you've exceeded somewhat your timing, but you've been sharing and raising a number of questions which certainly are going to be responded by the panelists. Let's follow now with the Greens. I understand it'll be Damian Bosselager.
Yes, thank you, Chair, and thank you everyone for coming and your interesting interventions. Professor Piers, you were talking about the long-term care workers, and Javier, actually under the leadership of Javier, we tried to get that into the blue card. Sadly, it didn't work. But I'm wondering now, do you think it even makes sense to write another sectoral legislation just specifically for this group of people? Is this what you would support, or would you rather say that we should try to include them into existing legislation, even though that might take more time? So just to hear your opinion on that more clearly would be very interesting. Mrs. Hornung, thanks for mentioning the transposition. I think that's crucial. I have a lot of thoughts on the EU talent pool, but I'll just ask a couple of questions. The first one being, you talked about a sectoral versus broad approach. If we think about what we also just said in terms of communication of the EU talent pool to third country nationals, does it make sense to have a sectoral approach where you basically go on the homepage and then they say, sorry, it's not for you? Or should we just have one homepage for everyone, a broad approach saying, hey, I want to work in the EU, this is who I am? Wouldn't it make it from a communication side more easily? And then that's more like a nerd question, but how do you set up a talent pool that it doesn't crowd out private offerings like LinkedIn, other matching platforms? How can you integrate the private sector into the matching of the talent? And then the foreign founders, happy to discuss this more. I think that sounds like an interesting idea to follow up. Ms. Levoy, I always talk about labor migration. I don't know if that falls in the right category or not in terms of wording. For me, I would be interested to understand how you see your role in the talent pool. What would be things that you would like to contribute in this matching process? I think you mentioned potential, standards and ethical recruitment, but it would be interesting to understand how you would see that technically happening. Thank you.
Thank you. Now, for ID, I understand it'll be Mr. Van der Driessen or Kim Weimers, Mr. Weimers, Van der Driessen. Who is making it for ID? You, Tom, Van der Driessen, or you?
Mr. Weimers is not yet a member of ID.
I'm sorry. Mr. Weimers is ECR. Then it'll be you, Tom.
ECR is normally first, eh?
2 minutes.
Thank you, Chair. Now, my EPP colleague stated that he would respect the official narrative on irregular migration. So I will be the boy in the emperor's new clothes. pointing out that if you enter EU territory in a way that breaks the law, we're talking about committing an illegal act. So illegal migration is the term I prefer to use. So what I would like to ask is about the long-term residence report recently endorsed by the EU Parliament. I want to ask Professor Peers about it. This report was adopted only a few months after Frontex reported the highest numbers of illegal entries to the EU since 2016, 330,000 in 2022. So one would think that migration proposals would be carefully designed so as not to strengthen pull factors for illegal migration, because the Frontex report indeed confirms that existing pull factors for illegal migration to the EU are indeed very strong today. The Parliament in this report now proposes that the rules for acquiring long-term residency should be amended so that the required period of residence for the acquisition of EU long-term residence status is reduced from 5 to 3 years, and that the entire period of time between the date of the lodging of the application for international protection and the date of the granting of the status of beneficiary of protection be considered as residency. It also removes derogations regarding equal treatment issues such as access to public housing and to employment reserved for EU citizens, as well as all integration conditions for joining family members. My question to you, Professor, is whether this policy, if implemented, is more likely to decrease or increase incentives for illegal migration to the EU. Thank you very much.
Okay, now it'll be ID. Thomas en Disje.
Dank u, voorzitter. Ik zal zoals altijd Nederlands spreken. De geschiedenis van de arbeidsmigratie is zo'n 60...
When we talk about labour migration, things really got going in the 60s and 70s in my country and in Germany, and it really led to some form of multicultural chaos. Now, migration, labour migration, there are reasons behind this. Why do people come from Morocco and other countries to Europe? Quite simply because the costs of labour were reaching such levels that there was a need to bring those costs down. The truth is that a new liberal, new colonial history is being replayed. Raw materials are being exploited first, and now what we're seeing is human resources being exploited in a way. People are being brought over. There's also another issue. Open borders just doesn't work. If you look at Flanders in the Netherlands, 40 to 50% non-Europeans actually are not in work. They're not on the active labour market. Many of the people from Ukraine, for example. And so if that's something we have to bear in mind. Look at Japan. Automation and tech were the solutions that were pursued. And look at Hungary, for example. They want a birth rate policy. So I think there's a narrative on migration where there's all this debate about irregular versus regular migration, whether criminal acts are being rebranded irregular. Do we have irregular rape? Do we have irregular burglary? Surely, I mean, I'd like to ask the speakers on the top table, do you believe that the millions of people you wish to bring to Europe annually in regular labour migration, isn't that just going to further exacerbate the problems we have already in our societies, really sowing all these divides?
Looking for a representative? Yeah, I know. Your point of order, surely.
Yes, and the speaker just also referred to me, so he also knows, and he's doing it on purpose. But, Chair, I would actually like there to be, because this is the umpteenth time that he is using far-right extremist language in this committee, and each time it's me asking for the floor. Maybe it's time that the leadership of this committee would respond to this. Okay, because we shouldn't normalize this. And it's getting normalized if we don't respond. It's far-right language. Just saying.
Freedom of speech is really what a democracy
It's
is all about.
far-right extremist language, Mr. van den
I
Driessen.
consider your speech extremist.
Sophie, let me make clear. Of course, I do have my own assessments, my own opinions about things I hear. This time, with the help of the translation, because I regularly follow live every speech. But when it comes to Flemish, I use translation. The only point I can make is that this is a house, this is a pluralistic house, and yes, there are extreme right seats in this house. Yes. I have my own opinion and my own assessments, but it's not for the presidency of the European Parliament or the chair of a committee to interfere with the points that are made on the representation of the constituents. Much as I dislike things I hear, this is a house in which points are to be heard of, are to be argued about. You have every right to oppose everything you hear, but as to the members expressing their views, I think this is the way Parliament
Frankly,
works.
Chair, racism is not an opinion.
Excuse me, racism is a criminal offense. If you say I'm a perpetrator of a criminal offense, then we will meet each other in court.
I have repeatedly asked for the Bureau of this committee to look into it.
Well, you made your point. Now let's proceed, okay? Let's go. I was looking for the left representation, which I don't see. Regrettably so, I don't see any other representative. You will be having a floor, but I understand there are some other members also willing to contribute to the discussion. It will be now Onorevole Pietro Bartolo.
Intanto ringrazio ovviamente.
Of course, I should like to thank the speakers and all the work that they have done on this issue which we are looking at. And of course, many of the elements in this debate I don't share. We've had the comments which have been made by our colleague from the right, and I think that it's important that we do challenge what is being said. Now, what we are looking at is irregular or regular migration, legal or illegal migration. Migration becomes illegal when we deem that somebody has arrived in an irregular fashion. What we want is somebody to come by regular routes. And, of course, what we also have to look at are the human traffickers and the importance of tackling those who are trafficking in human beings. So these are people who are trafficking human beings, and what we want is the sort of people who are coming in to be able to come in a regular fashion when they merit it. So this discussion on irregular migrants, economic migrants, etc., is one thing. But I do think that what we are working on, and I think we have to look at this along these lines, the single permit, the blue card, we're trying to come up with solutions to this. And we want to ensure that we work towards integration, that we shorten the duration of necessary for this. I think this has been excellent work And this is part and parcel of the whole blue card concept, so that people who come here can make a positive contribution to our economy and society. We certainly shouldn't be penalising people because they are claiming asylum. Of course, what's happening in Greece is something which we can challenge. We've seen boats coming in, we've seen children even on the boats, we've seen what happens, and what is happening we can describe as immoral. We have international agreements, we have the Geneva agreements, and it's important to realize that refugees who come to our shores should not be penalized. What we should be doing is giving them the possibility to come regularly to Europe. Naturally, people who are criminalized because they've been brought in by traffickers is not something we should be looking at in a negative way. What we should be doing is tackling the traffickers and ensuring that people have a regular way to come in. We want to actually succeed in getting a decent Europe here. We've got Directive 55, the temporary residence directive, looking in this context in people who are requiring and requesting asylum. We have to decide how we're going to behave. We have to ensure that we are aware of the facts. And that in Europe, not just in Italy, but in Europe, we realize that there are very important problems which we have to solve. When we are looking at small and medium-sized companies and also larger companies, we have to realize that there is a lack of workers. And it's important that we get people into the workforce. It's necessary. Europe needs people. It needs people for its economy. What I would say is that these people can help us. They can help us in terms of our democracy. They can help us socially. They can help us economically, obviously. So let us be careful about what we say. Of course, we have to regulate things, and we do have to control our borders. We do have to defend our borders, but we have to make sure that we're careful of what we're saying. We are talking about people. We are talking about human beings, just as we all are.
By your passions, try to observe the timing so that we may have our responses from the panelists. But now it's your turn. Sophie Inveld, free to go.
Yes, thank you, Chair. Just a very brief question to Mrs. Hornung, because we've heard from the, let's say, the business community for a number of years now that they have a very, let's say, positive, favorable view on legal labor migration, because very simply the economy needs the people. So then why is it that the business community, which is traditionally fairly close to center-right and right-wing parties, has not been able to convince those same right-wing parties to support legal labor migration? Because, okay, you're aware of how the debate goes in many countries. I'm sometimes very surprised to see business-friendly parties being anti-migration. It makes absolutely no sense. And yes, we need to take measures to better manage migration. That is very clear, and legal labor migration is a part of that. Because if some people say that some asylum seekers are not real asylum seekers, no, many people would like to come and work here. That's not a crime, and we actually need them. But it's very difficult for them to come to Europe outside the asylum procedures. So what is your plan, your message to those political parties? Okay, some of them are not going to be convinced, that's clear, but let's say the traditional center-right, business-friendly parties.
And now it'll be the next week, the Green.
Thank you. Thank you very much, all three, for your excellent contributions. And I would just make a first remark on the discussion that we just had. I think it's important that we have this freedom of speech, but freedom of speech is also limited by the prohibitions of hate speech and expressing support to criminal offences. So it would be important to have rules on our debates and also to enforce them. I have a few questions on, I think that we all agree that with the Temporary Protection Directive we have seen how vital it is that people have immediate access to the labour market. So it's really key, I think, that we try to learn from this also for other third country nationals. But the current EU system is very fragmented. It's not only because of the different regimes for EU nationals and third country nationals, but also within third country nationals. The single permit tries to streamline this a little bit, but it also depends on the different rights that those third country nationals have. And the practice is often much more unruly. It doesn't respond to the different legal regimes as such. I mean, people transfer from one regime to another. They have some gaps in their legal residence, or sometimes they lose their rights but are unable to return. So how could we make sure that this system that we have now is flexible enough to respond to the practices in reality? I think we already do certain things with changing employers, with everything that counts for getting the long-term residence status, but are there more possibilities to make it more fit for the practice, for the realities of people? And as it is already so fragmented, I understood from you, Professor Pearce, that you may suggest to make something specific for long-term caretakers, what Damien also said. Don't you fear also that it would lead to further fragmentation? Shouldn't we also try to have more convergence and one system? And Mrs. Hornung, you propose that we should amend the Family Reunification Directive. And I would wonder why. I mean, I see we have a lot of established case law on the directive, which also gives a lot of guidance to the member states how to interpret. We have implementation reports. So I see certain things that we could gain with this, but isn't there more that we can lose with reopening the Family Unification Directive in the current climate? And my last question is about the talent pool. It is a quite permissive system, I would say, because of the national competences of the member states on labour migration, and also the reluctance, indeed, of many member states to recognise there is a need to regularise labour migration. Do you see possibilities within this current division of competences we could still have a more promoting and encouraging policies if it comes to regulating labour migration? Thanks.
Okay. Now, let me reassure you again, dear Tineke, that I regularly speak out my mind on the European Parliament as an institution, on the kind of debates we have, and particularly on the kind of debates we have in this committee, which is so familiar to us at this stage, because we are growing old in this LIBE committee, some of us. We've been here for some time. We know how it's like and how it's actually evolving. So I have strong views. And whenever I'm given the chance, in writing or publicly, in my interviews, in my statements, of course, I make clear how I feel about certain things I hear. That is for sure. But when it comes to giving the floor to the political groups, I understand that the role of the presidency of the European Parliament, or the chair for this matter, for this committee, is to prevent that the dignity of the European Parliament itself, or the integrity, or the dignity or the honorability of individual members is preserved, is protected. So much as I dislike arguments I hear, much as I dislike reasonings I hear, I feel that it is the duty of a parliamentary house to argue about those lines of reasoning that may be not only subject to controversy, but asking for rebuttal. But much as I dislike them, this is the kind of work we do here. Contradict each other across the lines and at times compromising and building majorities and consensus. That is the point I wanted to reassure you about. I have strong views, but as I say, whenever I hear that the dignity of the House, the dignity of the committee, or the integrity or the honorability, the individual honorability of some members is to be preserved, of course, you can count on me. I will be there to prevent that from happening. But as for the rest, much as I dislike reasonings I hear of, this is the way we go when it comes to parliaments. Now, I will follow with the line. I understand that still, you may want to make a point of order.
I would recommend everybody to look at the minutes of this meeting and look at the term that is being used, not for the first time, because it refers to Nazi language. To be very clear what we're talking about. I do not consider that to be a simple opinion. Just check the text.
Okay. Point of order.
A small point of order. And why a point of order? Because the term I used, umvolking in Deutsch, is in German rather, is indeed a term used by the Nazis. And what do they mean by that? To move people out of their territories and replace it with other people, with foreign people. I reject this kind of policy.
Let's proceed, please, because we got to pay attention to our panelists and engage into questions and answers from them. But it'll be now Mrs. Bruma. Yes, you go. Yeah, you go. You got the floor.
Merci beaucoup, Monsieur le Président.
Thank you very much, Chair. Well, I must say that I'm starting to get fed up with hearing this terminology from the extreme right. It's even this concept of immigrant can be an extremist insult. And quite honestly, some of the members of parliament, yes, you have to respect their right to speak. But quite honestly, I don't accept this. Anyway, when we're looking at this directive, what we are doing here, I think, is taking talent away from countries that need it. We've seen countries training people. I saw a program relating to somebody who had been trained in his country and who had come here, learnt more and gone back to teach at home, which is a wonderful model when we're looking at these countries which need this. Now, on the directive, first of all, we're looking at Egypt, Tunisia, Morocco, Senegal, Pakistan, Bangladesh. Do you think that these countries who have people who have come into the European Union should swap what they have suffered for what they have got when they come here? We've got the irregular migrants who are being pursued by the Tunisians and by others. And really, are you sure that these are countries that we shouldn't be dealing with upstream so that we can challenge what they are doing in their own countries to these irregular migrants?
O să vorbesc în limba română. Sincer, mă bucur că este această audiere, dar iată că chiar în timpul audierii au apărut conflicte.
Well, it's quite interesting to have this hearing today, but quite honestly,
este o confuzie totală între migrați.
I think it's important to realize that the vocabulary that we use is very important. And there is a big distinction between legality and illegality, and this is crucial in the context of the implementation of our directive. I come from Romania, and we really do need labour, and we need the people who are coming in, the Senegalese and others, particularly for small and medium-sized companies, so that they have the necessary qualified staff. So they want to keep their doors open to people coming to work for them. Now, I think that what we need to do is to balance things out. We have supply and demand which regulate the labour market. And What we need perhaps is to have some kind of platform which will show what the different countries have need of, whether it's Romania, whether it's Poland, to show what these countries need and therefore to encourage people to come. So why can't we have this legal migration via a route of that nature? There are countries where IT is very popular. A lot of people are working in that area, and there are other countries that do not have enough people working in the field of IT and need them. Yes, I think that there is a need in the labour force. We need more labour, and it's important that we look at what we need and work on it. We need a talent pool. We need people to come into our labour market, and we need them to be treated equally. Making this distinction between legal and illegal migration means that my country, for example, which is alongside Austria, because we are outside Schengen, don't benefit in the same way. So there are certain rules which are not respected by Austria, and we find ourselves faced with a situation where we are told that what we are doing is illegal. I think we need to revise this, we need to monitor the implementation, and we need this to be simplified. We need it to be consistent so that legal migration is, as it were, done on demand. So we don't need certain types of migration or certain people, but when it's a question of legal or illegal, we also have to look at this concept of helping people and saving people when necessary. So I really liked this idea of having startup visas, because otherwise, if we're not going to have any immigration, how are we going to deal with the shortages on the labour market?
One by one, by the same order, not only free, but also welcome, expressly invited to state your views after having heard from the members, because they are the ones here representing European citizens, but you are our guests precisely to make your points as to the views and particularly the questions that have been raised. Yes, Mrs. Al-Salani, what is it now?
You know, Mr. Chair, thank you for giving me the word, but it just came to my knowledge when my colleague Sophie Intveld referred to the Nazi terminology here used, saying that we as refugees or migrants are replacing Europeans. And to be honest, this is a direct attack towards me, towards all people who are like me, who one day looked for refuge, for safety in this union. And you not reacting, I'm very assured that you have values that you defend, and I feel secure with your leadership. But you have to also admit that you don't know us all. You don't know what kind of terminology is actually directed against us. You didn't reflect upon the fact that I have another type of name that is not Swedish, that is not European, and that my colleague here from Belgium is directly attacking me on the same time as he is attacking all migrants, claiming that we are replacing the people of Europe by coming here as herds and in millions. So do take this with you, that there are other perspectives that you maybe don't see, but who are represented in this room and who feel attacked and who feel unsafe in this committee because we are considered to be a foreign element, to be something dangerous. Thank you.
I thank you. I thank you. I thank you for making your point clear. I said most of your interventions, I can follow them live. But when it comes to Flemish, I have to follow by interpretation. And maybe I'm not familiar with the word that in Flemish that has aroused such level of protest from you Flemish-speaking members in this session. and maybe I'm not familiar with the background, historic background of the use of that particular Flemish expression into the debate. But as to the theory of Ersetzung, that is replacement of the Bevölkerung, of the European population by someone else coming from abroad, I think this is an element of our controversy right now, of our debate right now. It's one of the distinctive elements of the kind of rhetoric, fear-mongering, hate-mongering that is characteristic of far-right nationalism attitude against all forms of migration, including legal migration, for sure. But it's precisely the point I was making, that much as I dislike certain lines of reasoning, we hear of them. We hear of them. We see them verbally and in writing. And we are here up for a fight. So I can only say that when it comes to filling the role of the chair, I feel that it is not my duty to abort the line of reasonings that I utterly dislike. It is my duty to give the floor and prevent that the dignity of individual members may be violated or insulted. You feel like it, you make your point, and you are absolutely right to do so. But anyhow, I will be aware that it arouses a very particular sensitivity when it comes to using that Flemish word that I heard in translation, okay? Anyhow, now we should be back to our panelists so that they may react to the points that have been said. Please. Well, it'll be 3, 4, 5 minutes each. I wouldn't be impolite. 3 minutes each. 3 minutes each. Please.
Thank you very much for those questions. So I'll address a couple that were addressed to me, as well as this question of language. I was asked about the economic argument for legal migration compared to the political divisiveness of it. But I think it's important to always emphasize and point out to the public that there are distinctions between people who are authorized legal migrants and people who are not authorized to enter. Now, those who aren't authorized to enter may end up being authorized to stay because they have a successful asylum claim, or some of them, of course, will not. But there's still a big distinction between them, and there's a legal distinction between them. As I pointed out, the ways in which you can address concerns that people have for labor migration is you can have national quotas for workers. That's built into the treaty. You will probably have labor market preference for most categories of non-EU workers in new legislation as well as current legislation. So I think that's those are ways of addressing those concerns. And if you've got, you can plan the numbers of legal migrants, you can plan public services and housing and so on with those numbers in mind. Two people asked me, should there be separate legislation for long-term care? I mean, personally, I would prefer it to be an amendment of existing law, either the blue card or single permit law. Maybe you don't need it at all, but if the EU wants to say that there are some categories of worker that it particularly wants to encourage, and it's already said this for researchers and blue card workers, but if there are others, then you will probably need some form of separate rules. They may be on family reunion, they may be on periods of stay, and various other ways in which you can encourage people to come and to stay and not be thrown out of the territory. So that would be the case for some type of rules, even if they're not in separate legislation. The next question I had was whether it's a pull factor to amend the long-term residence law. The last time I looked at the literature on pull factors for asylum seekers, the main features there were issues like whether people can find, family members or people from their community of their country or city, or have the language and links to help them find a job and find housing. Those are the sort of countries, the reasons why they prefer to go to particular countries and stay there. There's a big a community of a particular group of people. I don't remember it being suggested that the fine details of whether you might get long-term resident status was much of a pull factor. And on the particular points made, I think the issue of asylum seekers applications is already dealt with in the agreed text of the qualification regulation. There's already a lot of equal treatment in the long-term residence directive. I don't think the idea of a reduction to 3 years is going to be accepted by the Council, although good luck arguing for it. And finally, on the question of language, first, the idea of replacing people is a paranoid fantasy. No one is seriously suggesting that people who are here in Europe should be replaced. I'm perfectly happy with the idea of trying to train everyone who is here to fill job market gaps. But that won't happen immediately, as European business tells us, as we can see. Lots of jobs require lots of training. People won't always do them. It's hard to run a successful economy without some form of labour migration. And that can differ depending on perhaps public concerns or obviously economic conditions as to whether there's a need for migrant labour or not. But by all means, it's not the EU's competence really, but please do try and train the people otherwise who can do the jobs. And on the question of irregular or illegal migration, there's no comparison between rape and crossing a border. They're morally quite different things, obviously, and legally quite different things in many cases, because crossing a border illegally is sometimes purely an administrative issue. It is not always a criminal law issue. Case law on the Returns Directive says that it's administrative detention, not criminal law detention. The Refugee Convention makes it clear that irregular entry can still lead to qualification as a refugee, and it does so for very good historical reasons. There were people who had to leave the Taliban because, even though they didn't have authorized papers, who had to leave the Syrian civil war, who go further back, who had to flee the Cold War, or even further back. Raoul Wallenberg handed out really dubious residence papers to Hungarian Jews so they could escape the Holocaust. And that was the right thing to do. Refugee law sometimes requires that people break the immigration law of the country that they enter in order to find safety. And the Refugee Convention accepts that, and that's an important value, I think, that always has to be recognized.
Thank you so much, Professor Peers. Now, Mrs. Hornung.
Thank you. Let me maybe make, for the introduction to political statements, the first one is, the question in asylum law is, who needs us? And the question in labor law is, whom do we need? Those are two very different policy areas, and we should treat them differently, because I think everything else, and we've seen that here in the debate as well, I think everything else will obstruct good policy making. And the second point is, because that gets mixed up often too, domestic workers, domestic potential, of course we need to activate and invest in them. That just forms one pillar, and labor migration forces is another pillar. So I think it's very important that we don't play them off against each other, which we do very often, unfortunately. To the more technical points, Mr. Lenners, you asked on the recognition of qualifications, how that could look like. Right now, we have numerous documents that need to be translated and handed in, so bureaucratically, we can simplify a lot. Also, when it comes to the large numbers of authorities that are involved, there we could simplify. We can always carry out qualification measures in the companies, so the requirements, we could set them lower pre-arrival. Then you asked on the talent pool and SMEs. The talent pool definitely has a lot of potential, especially for SMEs. The big corporates, they know their ways. They have big HR departments that can place their vacancies, but SMEs are the ones that need support, and that's why it's so crucial that the talent pool goes via national contact points and public employment services who do post the vacancies, because I don't see a small SME logging into the talent pool and posting all of their vacancies. they will rely on their regional public employment services to do that. Mr. Sanchez, on the campaigning, we saw that with the blue card, which has been so highly underused. Yes, I think information campaigns and not only legislation is one crucial part where we need to get better in. Ms. Al-Salani, now gone, but maybe she watches it later again. She asked about the validation in the talent pool. I think here it's important that we have an automated approach on entry, which is easy, and then a validation and recognition process at a later stage, also then based on the prospects for integration. Damien Böselager, you questioned the broad approach versus sectoral approach, right? I'm often a fan of like starting small and making it really good and see what works and then extending it. But of course, I'm in favor of an ambitious talent pool. And if it's easier from the beginning to go with a broad approach, then that makes sense to do. If it is feasible to start small with a sectoral approach, then that would be something to advocate for. But it should indeed be a gradual approach then, and not the end. That it's only because, of course, shortages change, right? And then it gets very bureaucratic to update it all the time. And on the question how to integrate private platforms like LinkedIn and to the talent pool, for that, I'm afraid you need to ask an IT specialist, because of course that's something we as political actors, of course, say all the time, that we need technical operationality, but how that actually works technically, I don't know. So that we need to leave up to experts. And the last, Ms. Strick on the Family Reunification Directive. You asked whether if we open that, whether we might do more harm. I don't think so if we do a good recast. On the long-term residence, the blue card and the single permit, we also didn't do more harm, I think. It is just very outdated if you look at it, and it is not, if you read it, it has a certain taste. It's restrictive. It's not pro-migration when it comes to family members. So I think especially when it comes to the pre-entry conditions and also integration courses and a lot of requirements and those lengthy procedures, I think we do need an update. And my last point on the colleague, unfortunately I didn't see your name tag, but let me send a very clear message. We as a European business community are pro-migration, very clearly. And now, of course, I can only talk for the German employers. We explicitly stand for and ask for a welcome culture. We did quite large campaign activities and advocacy activities during the refugee crisis in 2015 and 16. We now became very active again in last year with the war in Ukraine. And yes, business-friendly, pro-migration is business-friendly. So I can't answer why certain parties can be in favor of one and against another one, but I can definitely assure you that we are very vocal on our values here.
Mrs. Levoy.
Thanks. First, on these more technical questions, on care workers, we actually don't recommend a specific pathway for care workers, but that they should be eligible under the general work permit schemes for admission for people from the EU. On small businesses, we see that if, in general, all of these procedures are working well, small business will also profit. But now it's quite burdensome and it's costly, not only for migrants, but for them as well. So I think in general, we see that a lot of the policies that we as civil society are advocating for migrant workers can also benefit from small businesses. On skills, we would recommend not only the recognition of formal skills qualifications, but also skills and experience that have been developed while. So, for example, there's a lot of undocumented migrants who have developed skills. They could also benefit from training and certifying while they're in the EU. And the talent pool and what NGOs could be doing, Basically, what we see now with the Commission's proposals is that it would filter people by skills levels and sectors, and we don't think that that would be very effective. So what we would suggest is to be serious about ethical recruitment, to look at the different sectors where there's a lot of exploitation of migrants. We know a lot of this from research, but also from civil society experience, including trade unions. So our role could potentially be to develop access criteria, to develop the vetting procedures for prospective employers and the applicants, to basically be able to adequately inform about the realities on the ground. And that's why we would recommend that it be a transparent process. And then the two last points that I want to make are on this bigger topic. One is terminology. So like it or not, the whole world is basically looking at regular migration. And why do we know this? Because the Global Compact on Safe, Orderly, and Regular Migration was adopted in December 2018 by 164 countries out of the total 193 UN member states. So we know this is a reality. 18 of the 27 EU member states adopted the Global Compact, which talks about regular migration once again. The EU research project Clandestino, which concluded about 13 years ago, found that the majority of people who are undocumented in the EU come regularly. The new project is called MIRAM. This is also funded by DG Research. It will also look at irregular migration estimates. We expect findings in about 3 years. But we know globally that the majority of migration is regular and orderly. And it's also interesting for you to maybe be aware that the UN Special Rapporteur on Migrants, for his final speech to the Human Rights Council in June, asked for submissions on the topic of regularization. So which countries are actually regularizing migrants? There were 76 submissions that were received, nearly 20 member states from throughout the world. And so there's not only a wide range of evidence on the policies and why they do them, but also how to do them. And the final point that I wanted to make, because Tineke was asking, how do we actually do this better? How do we make all of these disconnected processes better? Last week, when we were reviewing some of the findings from that project that I talked about on the single permit, which is basically about regular migration, to me, it was striking to hear that some of the people who were interviewed with having a single permit were finding difficulties in housing because of racism, because they experienced discrimination and racism. My final question to tie into the earlier discussion is, how much does the EU anti-racism action plan come into play in this whole discussion? On the migration policy, on the Libe Committee's discussions, how can it going forward? That's all I wanted to say. Thank you.
Thank you so much. It's been a quite intense discussion, for sure, because the point is actually much of our aim, much of our interest, legal migration, as a component element to change not only the looks of the whole thing, not only the way we see the whole migratory facts, but also how to respond, changing the prevailing negative approach, negative policy, at times in denial of the very facts, not understanding what it's about. So we thank you so much that you have enriched our discussion. But we are compelled to move forward because we have a second panel to go in a busy afternoon. We have some hours to go through. We still have to move on to the second panel. So we're inviting now the second panelists we are expecting. We thank you so much. Thank you, Professor. Thank you, Mrs. Hornung. Mrs. Leboy. Thank you so much. Thank you. Now, we are to hear from, first, Jonathan Shaloff, Senior Policy Analyst. And then it'll be Ralph Genetske, Director of ICMPD. So I suggest they take turns. Yes, 7 minutes each, so that we somehow compensate the overdoing of this first panel on good reason, for good reason, for sure. If you may approach the podium, we thank you for that. Of course, Thank you, Professor Pierce. See you next time. Now, please be welcome. Please be welcome. You've seen how it's like. We're discussing here legal migration tools. We have insisting on opening up legal pathways, legal ways to make it to the European Union without risking lives, and by the same token, enriching the European social fabric with a more positive approach to the whole thing. You're to share your views with us, and then you will be hearing the second round of discussions by turns. Okay, it'll be a round of points to be made by every political group, and then it'll be back to you. I suggest you make it in 7 minutes each, so that we may compensate the overdoing of the first part. Please.
Thank you very much. Thank you, Chair, members of Parliament. Thanks for the opportunity to speak today. So to cover very quickly, what I'd like to talk about is this question of whether the labor migration framework, what it needs to do in the next decade, and what it can do in light of the acquis and the competences and the limits of political feasibility. So first, just to come back to some of the points from the previous discussion, working on labor migration channels, I think it's important to underline that generally labor migration channels, and here I'm not talking about regular or legal, but migration channels designed to meet labor needs, are meant to benefit the residents of the receiving state. They're not about the migrant primarily. So the labor migration policy isn't to benefit the labor migrant primarily, but to meet the needs of the state, which are establishing these policies. And that's not to say that the migration shouldn't benefit the migrant, but that these benefits are not what usually drives policy development in the area of labor migration. And there might be other reasons to offer labor migration channels in exchange for something else, but this is not the primary purpose. So if we come back to the challenges in the background in developing a labor migration policy for the future, the first one obviously is this demographic transition and shrinking youth cohort and projected decline in the labor force and the issues of skills mismatch and employers reporting difficulty filling positions. And this is also in light of a global competition for skills and talent in which, as we heard, Europe has not been competitive. So if we look across OECD countries, the EU takes about 45% of the migration into OECD countries, if we look at the 2022 figures, but it takes a much smaller share of migration by qualified workers. This is just labor migration. So 45% of all labor migration, but a smaller share of the qualified labor migration. I think another point is that since each member state is setting its own objectives for what needs to be achieved through labor migration and assigns policy measures in order to achieve it, these vary quite a bit from one to another, and it's not really worth going into the differences, but the important common feature is that every single member state offers a legal migration channel, a legal labor migration channel for those who are considered to hold specific skills and talents that are sought in the national labor market. So overall, the EU actually has a very open political framework for skilled migration, for migration of about if there's a job offer. And this is not the perception outside of the EU of an open, skilled labor migration policy, but it is the fact of the settings in every member state. So the threshold of skills is different. It moves around quite a bit. We've heard already, and that's true in Europe, but it's also true across OECD countries that when there's tension in the labor market, the skills threshold tends to go down, and the definition of skills changes according to who's setting this politically and who's setting this in the labor market. So right now, if we're in a global, I wouldn't say panic, but a concern about skills shortages, many countries have been pulling out the stops in the labor migration channels. So if you just look around, there are really record target levels in places like Canada, in Australia, in Japan, and the UK has seen selective labor migration really increase enormously since Brexit. So the question now is, what does the legal migration framework need to do? It needs, as I said, to support member states in achieving these national objectives, while at the same time supporting these shared EU objectives. And here, one of these objectives is to assist member states in efficiently managing migration flows. And obviously that's by preventing them from being less efficient, but also to try to bring economies of scale and to avoid some of the pernicious abuse of certain other migration channels that might come up if there isn't a properly functioning labor migration channel in place. So the OECD has written extensively on some of the different ways in which the EU can provide added value to member states. And some of these have appeared also in the legislative packages and in the proposals that have come out. But I would say overall that the main one is to raise the profile of the EU as a whole so that the full weight of the single market can make each member state more attractive and facilitate its ability to meet its own objectives, the objectives that are set within that member state for the purposes of labor migration channels. So it's true that the legal migration framework is very rigid at the EU level. It's very difficult to do pilot programs. The policy development cycle is quite long, but still there are a number of ideas that are in the pipeline which can certainly address some of the needs and some in a way low-hanging fruit from a legislative point of view. The youth mobility program is something which has been discussed now for at least a decade, and I think this is certainly an opportunity for European cooperation. It's a kind of try and test visa to be able to explore labor market opportunities. We see that labor migration is quite often part of a two-step or three-step process, and it's important to have an initial phase to get familiarity with the destination. Job search visas, this is something that we've come up with explored some of the legal possibilities for this. But in the short term, it's important that non-legislative measures are adopted. And if we look at labor migration, there are certainly several possibilities. And I think the most important one here is really increasing the information about opportunities in the EU and increasing the information in the EU about opportunities to use the currently existing labor migration channels. And in this, the talent pool plays an important role. The idea of a talent pool, which doesn't introduce anything new in terms of a legal channel. There's no one who can come through a talent pool in any formulation who can't currently come to the EU under existing national schemes. So this is something which is designed not to represent new conditions for admission, but simply to facilitate the use of existing channels which are already in place, which already check the need, the demand for labor migrants in each individual member state. So it's not a question of creating the need to create a new regular labor migration channel, but one to provide more access to EU employers to the pool of candidates abroad. I would just, before closing, because I know we're in a hurry, 2 points. One is that fair recruitment is one thing which can be easily integrated into a recruitment platform. Fair recruitment principles is, if you look around at the models for the talent pool approach around the world, if you look at, for example, New Zealand, these are systems which incorporate fair recruitment practices and provide an additional level of supervision. The second one is this concern about, let's say, brain drain. In most cases, if you provide a channel for migration that allows people with certain qualifications to have access to a labor migration channel, then people will train for that. They will prepare for it. They will invest in human resources to use that channel. And on almost all cases that have been seen, there's a spillover effect, that you've increased the capacity of training. And these are individual choices that lead it. So there isn't really a risk of a talent pool somehow magically scraping all of the skilled people from around the world. So I would say the last point on additional value that can be developed through non-legislative measures in the short term is probably to reduce the migration costs and increase the return to full use of skills. And in that sense, efforts to facilitate recognition of foreign qualification should help not just the full use of skills of labor migrants, but actually a full retribution for those skills. And so to lead to gains both for the migrant and for the destination country. Thanks.
Thank you. That was, as for Jonathan Shaloff, let's hear now from Ralph Genetske, Director of ICMPD. If you may please tell us all, what does it stand for? We thank you too.
Thank you, Chair. Distinguished members of the European Parliament, many thanks for the invitation to ICMPD, the International Center for Migration Policy Development. One word, why we have been invited. We're an international organization working on migration issues. And since 2016, we have been working with the European Commission through a program which used to be called the Mobility Partnership Facility, is now called the Migration Partnership Facility. We have been supporting a number of pilot projects on legal migration ever since 2016. We had a first group where we had sort of 4 projects, and pilot is that we also speak about small numbers. We have now another 5, and we have more in the pipeline. So we see actually a momentum, and that's one part of my message, is we do see a momentum throughout many EU member states of interest in exploring and looking into options to work on labor migration, labor mobility. There are many words out there. I do like actually the title of the session, and that was my starting point. It's talent attractiveness. That is a second lesson learned actually, that what we see from member states, but also with the partner countries, that talent and labor migration, labor mobility comprises many different things. It can be mobility for entrepreneurs. It can be circular migration, can be seasonal work. It can be long-term. All this is part of it, and for all that is actually interest on the EU member state side and also with the partner countries. That was one point. A second point, I'm working for a migration organization, let's put it that way, where we have looked at labor migration always through the migration lens. I think it's fair to say that that has been the case over the past 20 years or even longer. I think what we see at the moment is in Europe that we look at labor migration much more through a labor market lens. And I think there we will, or we have already today, or we can have sort of a bit of conflict of interest, not of interest, but conflict of objectives. When you want to throw in legal migration in sort of the discussions with partner countries, you go to countries where there is a perceived issue with migration management. Now, when you want to attract a large number of potential labor migrants to Europe, you might go actually to totally different countries. So, and I think what we will see in the future, I think it's not an either or, but that we need actually both, and both can inspire each other. A third point I would like to mention is, I do think, looking back, and I look back and up to 2006, where we had the global approach to migration back then, where legal migration was absolutely part of it, but not much was happening. Let's put it that short and bluntly. I do think from a partner country perspective, the EU has a credibility problem, and this has to work on this. Partner countries by now have gone through many processes, dialogues, and so on, have developed their structures. They know very well what is happening in the world, in the EU, and so on, and have certain expectations. And they do expect that the EU has a credible offer when it comes to training, and then also labor migration or labor mobility. I think also talent attractiveness, it's not an issue for the future. I mean, what we see, the competition, as it is always called, and we always refer to the global competition, but when I look around in Europe, I see cities who are developing distinct talent attractiveness strategies. If you're in a federal system in an EU country, you will see that the different regions, they look on their own for their talent. So the competition, and of course you see then between member states, different initiatives and competition for workers, for talent, whatever you want to call it. So it is happening now. It's not an issue for the future. Final point, and we had the representative from the private sector. Absolutely. I mean, and coming from a migration world, we sometimes speak in abstract terms. We need 3,000 places, and we need this for. Now, each time we need an employer. There is an employer behind to make it happen. Otherwise, there is no labor mobility or labor migration. So that's a very obvious statement, I know that, but it is true. So if we want to pilot, and that comes again from our experience with pilot projects, to try to get the private sector in complicated schemes or projects, I mean, that won't work. We have to see what the private sector wants, where they want to invest, where they are ready to put money into future investments, and we see that SMEs were mentioned. I mean, SMEs, they don't want to take a big risk. Hence, why not looking into apprenticeships? That is where actually there is readiness because the upfront investment is, for instance, low. But just to say, it has to be simple when it comes also to private sector interests. But here, all this together, we do see a momentum, and sometimes I think also in countries in the EU, which are unexpected, which are not known to be upfront and very vocal about legal and or labor migration policies, but we do see I mean, such a need that there is this momentum, and we are trying, as ICMPD, we are trying to capitalize on that momentum at the moment through the pilot project, but also other initiatives. A brief word, it was not yet mentioned at all. We haven't spoken about talent partnerships. So here we go, because we situate sort of our pilot projects. They are not talent partnerships, but they are on the way towards supporting future talent partnerships. But I think we have to be clear about talent partnerships. Talent partnerships have been clearly framed as being a framework of cooperation with countries where there's a perceived migration management issue. So it's not a talent recruitment plan for the whole world. So I think that distinction is important, and that's when we have to measure it against this understanding. So we are trying to combine migration management issues with labor market issues, which is complex, but it's feasible. It's feasible, but it needs a lot of effort. It needs a lot of stakeholders, and it's important because it's also expected from our partner countries. There was a question before, actually, will we resolve the migration management issues? Will we, as Europe, we throw in talent partnerships, and then there's the partner countries will improve their return cooperation. That's often the expectation. My answer on that would be, it depends on the country. That's not very conclusive, but it's certainly one important element to show that Europe is serious about the expectations and what are put forward by the partner countries. I will have to finish. So conclusion, talent partnerships are important, provide a framework which also allows for cooperation and coordination among EU member states. But forward-looking, I think there's a lot of room to work at the level of youth, student, apprenticeship. And with our migration partnership facility at the moment, we're actually doing a small research, but I find very interesting. We are looking into expanding the possibilities of student work holiday schemes. Why are we doing this? Because I think everything related to youth, students, apprenticeships, it's at the level of creating also an emotional link with Europe, hence attractiveness. And my final word is, we can do the best things we want to do if our procedures are not fast and digitalized. If it takes 6 months to issue a permit, we are not attractive. Thank you.
Thank you both. Now, I feel it's my duty to remind you, and I'm only sorry, that by 4:30 we had scheduled nothing less than the presentation of the anti-corruption package by the Commission, and Commissioner Johansson is already in the room. So I ask you for your kind indulgence, your kind patience, because we are to complete at least a round of questions from the political groups. I suggest they make it in 1.5 minutes each, and then we will back to our panelists, so that we made this point complete. Jero, 1.5 minutes, please.
Yes, thank you. I'll be very brief. Just 3 questions. Maybe first to Mr. Shaloff. You mentioned the relatively low percentages when it came to the European Union and labour migration. Do you also have a qualitative analysis about why these percentages are low? You refer to the European system being rigid. Do you have other examples from the OECD member states member countries where we could learn something? How do you assess, for instance, the Canadian points-based system? Does that lead to more competitiveness in this in the area of labour migration? What are the pros and cons of a system like that? And to Mr. Genetske, given your experience with various forms of third country cooperation, and given the fact that also the European Union will at least intends to really emphasize cooperation with third countries in the wider migration context, what should be the main thing we need to focus on? What are the lessons you've learned in all these years of doing third country cooperation? You mentioned looking through the labour market lens. You've also mentioned that there are clear expectations from partner countries and the EU needs to be credible. What do these expectations entail, and what would be the level of credibility that the European Union needs in that respect?
Thank you. Now it'll be Birgit Sippel.
Thank you very much, and I will try to stick to some questions. Similar to what Jerome Lena said, we do have a number of different resident and work permits by the member states, and the rules are totally different. And it seems that there is not much readiness to get rid of it and have some more harmonized European rules, which I believe would be helpful so that people can ask for staying in Europe and not have to make a decision, will I stay in France or Sweden or any other country? Do you see a chance to get more readiness and improve the readiness of member states for more harmonized rules? I also agree that we do need people from the outside to work in our businesses, but I also see the problem of exploitation. Just last summer, I saw big public information that maybe the people serving you in a restaurant are exploited, and we are talking about people from third countries. So do you see the danger that we are looking for people from third countries because our business are ready to lower wages, not give them the social support that our own citizens would receive? So is this a way to abuse and water down social security? And what can we do against this? And talking about the lack of people working, do you see that if we improve working conditions and higher the wages, that more people would be ready to take the job and we were not forced to ask for people coming from third countries beyond those who are on high level? How do you see the chances to avoid exploitation? You might have just seen the problem of some drivers who were on a parking place because they were not placed for long. Thank you.
Now it will be Sophie in Veld. Please, make it in 1.5 minutes, please.
Oh, I can be much more, shorter than that. Echoing also a little bit the question that was put in the previous round by my colleague Abir Salani, is we are not the only continent looking for labour force. Do you think we're still, let's say, on time when it comes to the battle for brains and hands, or are we losing out already? Are we attractive enough as a continent? And okay, you've already given a lot of pointers of what should be done, but how are we going to turn around the public mood? We see certain countries which until recently were emigration countries. There are countries where there's actually been massive emigration. I think, well, Bulgaria is one of the countries where I believe since the early 90s they've lost like 30% of the population. So how are we going to turn that around, not just in terms of policy measures, but also the public discourse of parties, political opinion, and what have you?
Thank you. Now, Damian Bosselager or Tineke?
Very quickly, one question from my colleague Tineke in regards to the question of talent partnerships focused on countries where we want to see more return. How does it actually help the people who are, migrating through these countries? How can we ensure that there are decent living conditions there? Is it really sensible to bundle that? Is that correct? No. Okay, go.
sorry, my question is about, you said that talented partnerships are sometimes offered to countries of a region to let them cooperate on returns, but you see it more and more also used for transit countries. Like now it's been proposed to Tunisia, where we actually want Tunisia to step up border controls and pullbacks of migrants. So these two things are, in my eyes, not related, and it doesn't do anything in terms of improvement of the position of migrants, and migrants cannot profit from this talent partnership. So what do you think of imposing this whole concept to transit countries with a completely different population than the third country nationals who try to travel onward?
Be super quick. Sorry. One quick question to Mr. Chalov. How do we make sure that this talent pool doesn't just become another dead tool, potentially like Eurus or others? And how can we keep it open and agile? To Mr. Genetzke, how do we get the labor ministers, or even better, the ministers of the economy around the table when we discuss labor migration rather than the interior ministers? Because you mentioned that. Thank you.
Thank you. Now, any other member in the room willing to make a short contribution, no more than 1 minute? Anyone raising a hand? If not, we're back to the panelists. Okay, I'm sorry to haste you in this final track, but the Commissioner, Home Commissioner Johansson is already in the room, so please proceed.
So very quickly, why is Europe not attractive? What is keeping the numbers so low? As I said, the policy is open. It's employer-driven. So clearly, one factor is that employers are not using it. Why not? Because it's complicated, or because it's difficult to find the kind of profiles that they're looking for. They don't know how to find them. There's the language issue. There's a challenge there. Would a Canadian approach work? Probably not. We've written about this. You need to know a lot about the success factors if you're going to bet on someone and give them immediate permanent residence. That's something which there isn't really that kind of information. It's hard to pick a winner. So the system which is in place now, where people come, let's say on a trial basis, temporary permits, in most cases, students, so on, get familiarity, move into the labor market, that is the effective method. So the question is, how can you open that funnel wider at the beginning in order to ensure that you can increase the numbers later? So there is a possibility. I don't think it's too late. The talent pool, to make sure it's not dead, it takes some patience. None of these platforms work immediately. It takes a few years for them to take off. And there's quite a bit of work of branding to be done. There's really very little branding being done right now. There's no infrastructure, there are no resources, and that's one area which is, let's say, fairly easy to address. In terms of harmonizing the permit categories, this isn't necessary. I think what you can see, the need for harmonization, you can already see that when, if you look at the increase, for example, just in posting of third country nationals from one EU country to another, you can see that the existence of a labor migration channel in one member state, which admits people who are then posted to another member state, tells you something about the overall need of the EU labor market, and it also raises a flag about increasing let's say, compliance and inspecting workplaces to improve working conditions and prevent exploitation. In fact, for third country nationals, through this mechanism, there's already a single labor market. So you come into one country and are employed in many. And I think this is something to keep in mind and to watch out in the future, because this may be one factor which drives policy development.
Thank you for making it so sharp. Mr. Genetzke.
So cooperation with third countries, or I prefer partner countries, again, it has to be very targeted, very specific to each country. For some country, a joint political statement might be sufficient, and it's more the political gesture. In another country, money matters, and enhanced funding for all sorts of things can make a difference. So I think there one can have a whole catalog of things, but the basic, and that links also to the last question, or actually with regard to the transit countries, Tunisia was mentioned. I think the starting point is the very fundamental understanding about the situation in the partner country. I think then, and that's how I understand initiatives from the past about partnerships, migration partnerships, or bilateral partnerships, you can put into that a lot of things.
You could, for me, that would be an option to say, well, we work actually on if talent is developing skills in the partner country. You could have a component where, if the partner country agrees, transit migrants, in whatever status they are, has to be defined, could be part of a program. So I think there are different configurations, but the starting point is really this understanding of the country. The second point is not only the what, but also the how it is done. And I think there, from the European side, it has improved a lot the last years. Is it about continuous engagement? It's about, when it's about high-level meetings, everybody is high-level. It's really the continuous engagement among colleagues in the end, because what I said at the beginning, also the partner countries have gone through many, not only the Global Compact discussions, but many dialogues, processes, qualified people, and so on. Harmonized rules at the European level, if you ask me, by all means. I mean, this is about attractiveness. Again, I mean, this will be a slow process, but I think it's showing that things work. That it's not about abandoning and suddenly we have something new and then nothing works. So it's a slow process. You asked especially about exploitation. I think that is a very interesting one, has to be carefully watched. I find very interesting, for instance, seasonal work, which is often equivalent to exploitation. We have at the moment a pilot project, actually it's between Morocco and Spain, where it is about seasonal migrants, very well known, the schemes. But there's a component, for instance, then back in Morocco, where it is actually about socioeconomic possibilities. So you can add things which could concern rights, or actually also when people go back, financial literacy or other things which we know from development cooperation. So there are things actually one could work on. Sorry, I might miss something, but to come back to the ministries of labor, I think initiatives are underway. It is for people like me coming from the migration world to reach out and we will do many more events actually where we have representatives from ministries of labor. I understand, and here I have to look at the commissioner, the initiative, I forgot the network you have set up, I think it was in January, where you brought together actually, and was co-chaired by the commissioner, but also Commissioner Schmidt, I think it is for employment. So this is on the table, I think. It has to be intensified. Again, as a migration person, I would say the labor market needs, they will be ever more evident and will actually drive ever more the agenda when it comes to labor and legal migration. I'll stop here. Thank you.
We thank you so much. We thank you. Thank you for the contribution to the discussion. It was worthy that we filled this first point of the order of the day with a round of views on legal migration tools, legal migration files, legal migration views. We thank you so much. Now we invite to the podium Ylva Johansson, please. Thank you so much. Thank you, John. Thank you. How are you? Again, we thank our Commissioner Johansson for her patience. We are ready to go to the following point in our agenda this afternoon, which is related to the presentation of the relevant new